Good morning, everyone. Welcome to the fourth and last in this year's series of New G lectures from Wilberforce Chambers. We've ranged in subject matter from contribution breaks for employers to rectification to prudence in investment. And today the finale is talking about tax. As a subject, it sometimes evokes in me the same reaction as pensions does for non-pensions practitioners, which is something along the lines of no thanks, who can I ask? But I'm delighted that the three speakers that we have today have a reaction more along the lines of tax, bring it on. And they are, in order of speakers, Jonathan Davey QC, Michael Furness QC, and Robert Ham QC. And they're speaking in that order. Before I hand over to them, can I explain how we'll take questions? At the bottom of your screen, there should be a button marked Q&A. And if you type the question in there, we'll deal with questions at the end of the three talks. So if you'd like to direct your question to a specific speaker, then please do add that in. Well, without any further ado, can I pass over to Jonathan to start our three talks today?
Thank you, Tom. Good morning. What I'd like to do over the next 15 minutes or so is talk about two matters relevant to the taxation of pension schemes, both of which have been dealt with in an important recent Court of Appeal case that was heard shortly before lockdown. That was in the old days when people used to go to real rooms, known as courtrooms, and address real people, at least sometimes known as judges. The case in question was Gareth Clark and the Revenue. And I'm hopeful that I've shared my screen with you. I was counsel for the respondent, the Revenue, in that case, and the two matters that I'd like to talk about today concern payments and discoveries, as the title of the talk suggests. Specifically, the issues I'd like to talk about are as follows. Number one, the meaning of the word payment for the purposes of the phrase unauthorised member payment within section 160 of the Finance Act 2004. Number two, the question of what comes within the scope of a discovery assessment made by the Revenue under section 29 of the Taxes Management Act 1970. I'm going to spend most of my time talking about the first of those two issues, but I will say a little bit about the second towards the end of the talk. The 2 points are, if you like, logically distinct. The first might be viewed as essentially a substantive legal question, the second as administrative or procedural in character, but both are important to have an awareness of if you are advising or litigating in this area. So that's what I'd like to talk about. To place those issues in context, the facts. The case concerned one Mr. Clark, a retired businessman. Mr. Clark had become unhappy with the returns he was getting from a SIP which he had with Suffolk Life. He was also keen to have access to money in order to be able to invest in the London property market. Against that backdrop, he was put in contact with an outfit which described itself as a specialist boutique providing innovative taxation solutions. The boutique proposed something called the Pension Transfer Plan. The plan involved a number of steps, some 21 or so to be precise, but you'll be pleased to hear that I'm only going to ask you to keep in mind 2 steps plus one related first instance finding. The 2 steps are numbered 1 and 2 on the slide. First, the transfer of £2 million from Mr. Clark's Suffolk Life SIP into what was purported to be a registered pension scheme, known as the Lavisham Pension Scheme. Number 2, subsequently, the transfer of £2 million from the Lavisham Pension Scheme to Lavisham Marketing Limited. That was a company which had been incorporated as part of the pension transfer plan and which had established the purported pension scheme. Following those steps, plus a further onward transfer to a company of which Mr. Clark was director, Mr. Clark was able to receive the loan finance which he wished for and invested it profitably, buying and selling property in the Mayfair property market. Some of the money was paid back, some of it was not. The other important ingredient, and this is point 3 on the slide, is the first instance finding that the trusts of the Lavisham pension scheme were void for uncertainty. That followed the judgment of Mrs. Justice Rose in the case of Re LPA Umbrella Trust, the 2014 Chancery Division case, where member benefit provisions defined in like terms to those in relation to the Lavisham scheme were found to be void for uncertainty. The reason that was important was because in circumstances where the Lavisham pension scheme was void, it was held to follow that the Suffolk Life transfer, that was transfer number 1 that we looked at, only ever conveyed bare legal title to the money with an immediate resulting trust arising by operation of law. The Court of Appeal did not interfere with that finding, citing a passage from Lewin on trusts, which is on your screen now. So just taking stock, the situation which had arisen was that there had been a transfer from the Suffolk Life SIP bank account to the Lavisham Pension Scheme bank account, and then from there to the Lavisham Marketing Limited bank account, and then from there onwards to Mr. Clark, who put the money towards buying and selling property. But the fountainhead from which all of that stemmed, the Suffolk Life transfer, as it happened, had only ever passed legal title, nothing more. So why is this relevant from a tax point of view? Well, the reason it's relevant is because income tax is chargeable if a registered pension scheme makes a payment to or in respect of a member which is not within the list of authorised member payments under section 164 of the Finance Act 2004, which includes such things as paying a pension. That charge to income tax is known as an unauthorised payments charge, and it may be that many of you will have been involved in transactions or disputes where the question of whether an unauthorised payment charge arises has been live. In Clark, the particular question which arose was whether or not that first transfer, which we looked at, was an unauthorised member payment giving rise to an unauthorised payments charge. The Revenue said that it was. The transfer made did not fall within the list of authorised member payments. Mr. Clark said that it wasn't. The reason it wasn't an unauthorised member payment was because the transfer made was never a payment at all. And the reason it was never a payment was because for something to constitute a payment, legal and beneficial interest must pass, and it had not done so here. Now, those two opposing positions, yes, there was a payment, no, there wasn't a payment, were both advanced against the statutory backdrop of the Finance Act 2004, and we need to spend a few moments considering that. This will be familiar stuff for many people, but just to keep things simple, within the Finance Act, pension schemes are dealt with under Part 4. Within Part 4, payments and related tax charges are dealt with at chapters 3 to 5. And although those chapters include many provisions, ultimately the wording directly relevant to the definition of payment is pretty limited. It's at sections 160 and 161. So 162A says, in this part, unauthorised member payment means a payment by a registered pension scheme to or in respect of a person who is or has been a member of the pension scheme, which is not authorised by section 164. We then have section 161, 1 to 2, which says, this section applies to the interpretation of this chapter. Payment includes a transfer of assets and any other transfer of money's worth. And that's it. There are arguably some other signposts. For example, there is a subsection B to section 162, which is on the screen there, which refers to anything which is to be treated as an unauthorised payment. We don't need to consider that for present purposes. The headline point is that such signposts as there are, or arguably are, provide minimal guidance on the pure conceptual question of the meaning of payment. Now, if we were in person, at this point I would ask for a show of hands on this to see how many of you think that in Mr. Clark's case, a payment had been made, and how many of you think not. Remember, the transfer in issue is the original one from the Suffolk Life SIP to the purported Lavisham scheme. I can't do that because you're pleased to hear I can't see you sitting there merrily eating your breakfast or whatever it is. But with the help of my colleague Hayley, I can put a proposition on the screen and ask you whether you agree with it or disagree with it. So, yes, in order for something to be a payment, legal and beneficial interest must be transferred. Do you agree, disagree, or do you not know? Please vote. And I'm going to give you a full 8 seconds to think about it. Now, I think either the wonders of technology are going to tell me the answer in due course, or they won't. But what I will say is that, here we go. Right. Agree 45%, disagree 43%, don't know 12%. That's very interesting, actually, because certainly prior to Clark, a fairly orthodox view was that the case law pointed in two diametrically opposed directions, providing support for each camp. And I think the poll we've just taken perhaps accords with that. As you might imagine, a good deal of judicial ink has been split on the meaning of payment in various contexts over many years. For a closer look at the decision in Clark for a way to get to those authorities. In the limited time we've got this morning, I'm just going to mention two cases. Number one, the case of Hillsdown. That was the case heard by Mrs. Justice Arden, as she then was, and concerns section 601 of the Income and Corporation Taxes Act, dealing with the charge of tax on payments to employers under the pre-Finance Act 04 regime. Number two, Venables. That was a case which made it all the way to the House of Lords, but the relevant judgment for present purposes is that of Lord Justice Chadwick in the Court of Appeal. It concerns section 600 of ICTA and dealt with the charge of tax on unauthorised payments to employees. Now, both cases repay careful reading, but the headline point for our purpose is that in Hillsdown, the court's position was that a transfer which failed to pass beneficial interest did not constitute a payment. Whereas in Venables, the Court of Appeal's position was that a transfer which failed to pass beneficial interest did constitute a payment. Lord Justice Chadwick, in perhaps characteristically confident fashion, contending that the contrary view was, quotes, plainly wrong. Now, what the court helpfully brings out in Clark is that in considering Hillsdown and Venable, appreciation of context is crucial. Cutting matters very short, in Hillsdown, what was being considered was a payment by a scheme to an employer to reduce a surplus. On the face of things at least, it was permitted, and if tax was due under section 601, it was against that backdrop and on that premise. By contrast, in Venables, what was being considered was a payment to a member, which was being analysed on the basis that it was not permitted, and if tax was due under section 600, it was against that different non-Hillsdown backdrop. As the Court of Appeal put it, the charge to tax under section 600 arises only where the payment is unauthorised and in breach of trust. If an unauthorised payment is to be treated as no payment at all, the section is self-defeating. That cannot have been Parliament's intention. Now, ultimately in Clark, the Court of Appeal saw the relevant Finance Act 04 provisions as falling to be analysed in broadly the same way as the ancestor provisions analysed in Venables. Lord Justice Henderson said, the charge to tax, i.e. the unauthorised member payment charge, would become self-defeating if it did not apply to cases where the payment was made in breach of trust or for any other reason did not transfer beneficial title. The crux of the Court of Appeal's conclusion can be found in a particular paragraph, paragraph 82, and I've broken Wilberforce House rules for the number of words on a slide by putting them all on the screen as follows. I'm not going to read all of those out, but what one can see there is where the Court of Appeal got to with those underlined words. The question whether a payment is made should be answered by looking at the practical business reality of the transaction, including any composite transaction of which the payment forms part. It should be said that the facts of the case weighed heavily on the court. In contrast to, say, Hillsdown, this was not a case where the sums had been paid back prior to the matter coming to court. The court spoke on more than one occasion of the natural reaction that someone would have on being told that a person who had obtained funds to buy and sell property just off Park Lane had never received a payment in the first place. The natural reaction in the court's view was that the no payment analysis could not be right. So that is where the Court of Appeal ended up. A point to end on perhaps on this first issue is to say that opinion may be divided on whether the upshot of Clark is that we finally have clarity on an important point of principle, which has been at large for a long time, the meaning of payment in this area, potentially relevant to many cases, or alternatively, whether what we have is an example of the Court of Appeal disregarding conventional principles of equity in order to reach a conclusion they felt was right from a merits point of view. It's also worth noting in that regard that the Court of Appeal does appear to leave some wiggle room for cases which have a rather different fact pattern, remarking at 86 that different considerations may arguably arise in cases where an unauthorised payment is inadvertently or carelessly made, and the member concerned takes prompt and effective steps to restore it to the fund before any assessment is made by the revenue. Those words may be of some importance in some cases. That's most of what I wanted to say. In my last few minutes, I want to touch on the second issue that I flagged at the start of the talk regarding the scope of a discovery assessment. Some of you might not generally get involved in the nitty-gritty of assessments of tax. Others may be involved with them on a regular basis. In any event, I simply want to do two things. Number one, tell you what a discovery assessment is. Number two, say something about its parameters and why the question of its parameters matters. In terms of the first of those, and starting with the basics, if a tax return is filed on time, the Revenue has 12 months from the date of the filing in which to issue a notice of inquiry if it wishes to investigate further whether the right amount of tax is being assessed. When the time limit for opening inquiry expires, or an inquiry which has been opened is closed, the taxpayer's liability for the relevant tax year is generally regarded as final. In these circumstances, the Revenue can only demand a further tax payment by raising a discovery assessment. The relevant legislative provision is Section 29 of the Taxes Management Act 1970. That section has been amended several times. I'm going to show you the version in force for the purposes of Clerk. The words are on your screen now. I'm not going to read all of those words out, but you can see them there. The word I want to focus on is the word that is underlined, discover. That word has been part of the taxing legislation for a very long time, but never been statutorily defined. The case law dealing with its meaning goes back well into the 19th century. Again, for chapter and verse, see Clerk for a way into the relevant authorities. But in essence, the point to keep in mind is that the term discover, the concept of discovery in section 29(1 is essentially subjective in character. To speak of a revenue discovery is to describe an officer coming to a conclusion based on the information that the officer has. As the Court of Appeal put it in Clerk, the scope of the assessment and of any appeal from it must be defined by the subjective discovery that the assessing officer has made. That is the only assessment which the officer has jurisdiction to make, and the scope of the assessment, as opposed to the arguments which may be used to support it, cannot, in my view, be extended by virtue of the appeal process. The reason it's important, this is important, is because it means that what the officer does and says in correspondence with the taxpayer really matters. In Clerk, the issue was whether the discovery assessment correspondence established that the Revenue's focus was only on the second of the two transfers that we looked at. That mattered because if the Revenue's discovery did not include the first transfer, no tax was due because it was agreed that the second transfer could not be an unauthorised member payment. Remember, the Lavisham pension scheme turned out to be void and therefore could not give rise to a charge to tax. As regards the first transfer, the issue was that even if the transfer did constitute a payment, unless it also came within the scope of the discovery assessment, then there was no tax liability. The Court of Appeal found that properly construed, the assessing officer's discovery assessment correspondence, which included reference to an ongoing investigation into what was a composite series of transactions, was broad enough to encompass the first transfer, and therefore there was an enforceable tax liability. The reason that all of this matters is because it illustrates the importance of real attention to detail in reviewing what the Revenue is asserting in any discovery assessment or associated correspondence. This is a potentially big topic of which I've only just scratched the surface, but to finish, and perhaps as a start for 10 for future thinking, some points to keep in mind in this area. Number one, does the transaction in question fall within the scope of the discovery asserted? That's what we've been looking at for the last few moments. And there are other considerations too to keep in mind. For example, has the discovery gone stale? Has the Revenue sat on its information too long, with the result that the opportunity to issue an assessment has passed? That can happen. The case of Charlton against the Revenue in 2012 is an example. And thirdly, are the other conditions for issuing a discovery assessment present or absent? So for a discovery assessment to be made, unless the loss of tax has been brought about by carelessness or deliberate action by the taxpayer or a related person, then the Revenue will need to be able to show that it could not reasonably have been expected on the basis of the information available to it at the expiry of the period on which the inquiry could be opened or on closure of any inquiry to be aware of the facts leading to the potential loss of tax. So the question to ask is whether one of those conditions, and they're at sections 29(3) to 5 of the Taxes Management Act, whether one of those conditions is met in the case in question. That is all from me. To conclude, the lesson from Clerk, in my view, is that close attention to detail in analysing the sorts of matters we've been looking at this morning can have the potential to make a real difference for your client, both in considering, number one, substantively the proper analysis of transactions that have occurred or might be in contemplation, and number two, procedurally, where matters stand, and ultimately the location of the goalposts in dealing with the revenue. Thank you very much for listening. That's all from me.
Right, I think I'm not. It's now down to me, I think, to take over and see if I can also share my my screen here. I hope we can all see that. As you'll see, my talk is on in a way, a topic that's almost the reverse of what you've just been hearing about. Which is not where payments are made, perhaps in excess of what a member is entitled to, and the consequences of that, but circumstances in which, in the past, a member has received less from the scheme than he's been strictly entitled to by way of pension, and at some point after the event, the trustees come to realise that they have been making underpayments. They have to make payments of arrears and pay interest on those arrears. And the question is, what is the correct tax analysis of the payment of those arrears and the payment of any interest? Now, arrears can arise, obviously, in a number of situations, of which perhaps the most obvious is a simple computational error, which might simply affect one member or a handful of members. But these issues become really important where you have arrears arising on a scheme-wide level. For example, if you get a court ruling that the meaning of the scheme rules is different from what the trustees had previously supposed it was, with the result that benefits have to be recalibrated at a higher level. Or also the situation I think many of us will have encountered in recent years, where past amendments which had purported to reduce benefit accrual turn out to have been invalid, with the result that the benefits have to be increased to the original rate of accrual. In all of those situations, you end up with a situation in which the member is going to be receiving in a given tax year a lump sum which represents the underpayments from previous years. And in many cases, they will also be receiving a payment in respect of interest for having been kept out of their money for a period in the past. So what's the issue? Well, the issue here is whether or not you can fit the arrears and the interest payments into the concept of an authorised payment. You'll all be aware, I'm sure, that all payments out of a registered pension scheme are either authorised or unauthorised. The basic principle is that they're all unauthorised unless specifically authorised by the legislation. And unauthorised payments can lead to what can often only be described as penal tax consequences, typically a tax rate shared between the member and the administrator of 55%, although in extreme cases it can go up to 70%. So it's key in examining this question to start by looking at what payments to members are in fact authorised, and they're set out in section 1641 of the Finance Act 2004, and this is just a very summary list. Each of these concepts has additional defining wording, but it's, as you can see, pensions, lump sums, transfers, what are called scheme administration member payments, which we'll come to in a moment, pension sharing payments, and payments of a description prescribed by regulations made by HMRC. Now, when we're looking at arrears, the obvious place to go to would be the Registered Pension Scheme Authorised Payments, Arrears of Pension Regulations 2006, which you would think would be the place to go to find out how to deal with your arrears problems. And I think there's a fairly widespread view out there that you don't need to worry too much about the tax treatment of arrears because they're covered by the arrears regulations. Sadly, that is not so, because when we look at the arrears regulations and what they actually apply to, here is the wording. The regulations apply to so much of a payment as, and then look at this, does not exceed the amount accrued during the period ending with the date on which he became entitled to the pension, the actual start date, and beginning with the earliest date from which the member could, at the actual start date, have required the scheme administrator, etc. So you're looking at that. and you're saying to yourself, how is it possible to have arrears for a period which ends, which have accrued during a period which ends on the date when the member has become entitled to the pension? Surely that's the start date. If you've got a member who's got an NPA of 65 and by mistake his pension isn't put into payment for a couple of years, maybe the trustees have lost his address or something, surely the arrears start from the point at which he becomes entitled to the pension, i.e. age 65, and end at the date when the pension is put into payment. The puzzle here is resolved by the fact that the Revenue have what I think many people would describe as a rather eccentric view of what becoming entitled to a pension means. And this is explained in the explanatory note to the regulation, and it's also endemic in the pensions tax manual that the Revenue take this view. The Revenue take the view that you do not become entitled to a pension for the purposes of the legislation until it's put into payment. So the Revenue's view is that if you are entitled to a pension age 65, but it's not put into payment till you're 67, your entitlement to the pension arises at age 67, not at age 65. Now, with the benefit of that interpretation, one sees that the arrears regulations, in fact, only apply to arrears which are built up before the pension is put into payment. So they do apply to that simple case where there's been a 2-year gap between the date of normal pension age and the date when the trustees track the member down and start the payments. That's exactly what the arrears regulations are there for. They do not cover arrears which have been built up after the pension has been put into payment as a result of an underpayment of the pension while it's in payment. And the latter arrears, because they're outside the regulations, have to be justified as payments of pension. If we go back to section 1641, you see, if you're not within F, really the only place that you can logically fit your arrears payments is that they are belated payments of pension under 164A. And that's where your arrears have to go. And this is a view, although it's not spelled out in the manual, which HMRC have certainly accepted and indeed adopted in cases that I have seen where these issues have had to be resolved. Okay, so you're going to justify paying your arrears as payments of pension under 1641A. Now, 1641A only applies to payments of pension which have been made in accordance with the pension rules. And the pension rules prohibit the payment of a pension which is not a scheme pension. And it's a requirement of a scheme pension, as you see there, that the rate of pension payable at any time during any 12-month period is not less than the rate of pension payable at the relevant time. And the relevant time is the beginning of any 12-month period. Now, the drafting is, as usual, rather clunky, but it's fairly easy to see what it means. It's aimed at pensions. It's aimed at prohibiting having pensions which decrease in value as time goes by, because there'd be an obvious anti-avoidance, obvious avoidance possibilities if you were allowed to do that. So to be a scheme pension, the pension either has to be level or it has to go up from one year to the next. It can't go down from 1 year to the following year. But of course, if you're paying a big chunk of arrears in one period of 12 months, the likelihood is that there will be a lump in the member's receipt of pension. So if you're running at a rate of £10,000 a year for your pension, disregarding indexation, and then you qualify for £5,000 of arrears because you've been underpaid in the past, your pension will go up to £15,000 in a given period of 12 months, and then in due course will drop down to 10. And at first sight, that means that if you're going to justify your arrears as payments of a pension, you're in danger of having that pension breaching the pension rules. Now, the tax justification for allowing the payment of arrears to qualify as a pension, and this does again appear to be accepted by the Revenue, as I've seen in cases where they've corresponded, although again you will look in vain, I think, in the pensions tax manual for any guidance on this. is that HMRC will allow the lump sum payment to be spread over the years in which it's arisen, and their views on that are to be found really not in the Pensions Tax Manual, but in the Employment Income Manual. This is based on the proposition that employment income is taxed on an earnings and not a receipts basis, and therefore, although your arrears all fall in one lump sum in a particular year of assessment, and for PAYE purposes must be treated as paid in that year, the revenue and the member can treat that lump sum payment as essentially accruing over the years of assessment in respect of which the arrears have actually arisen. And that can be important for the member, because a big lump sum put through PAYE in 1 year might push the member into higher rate tax, for example, when they wouldn't otherwise pay it. But they can then, and this is the member's responsibility, not the trustees, go back to HMRC and avoid that higher rate by reallocating that lump sum over perhaps several years during which the arrears accrued. So that is the theoretical basis for not breaching the pensions rules and treating a lump sum of arrears as a payment of pension. Then we have the problem that many of these sorts of cases where there is a dispute over the level of pension are compromised. Whether it be a compromise for a question of construction, or compromise over the question of whether previous amending deeds are or are not invalid. It's very often the case that before the court, the members will accept a percentage of what they might otherwise be entitled to. So the question here is that your arrears will not be actually, at the end of the day, a sum which is authorised by the rules at all. The rules will either say perhaps that the member is entitled to no arrears at all, or they're entitled to £10,000 of arrears. But if there's a 50-50 deal and they get £5,000, will HMRC accept that that is also a payment of pension? And the problem is particularly acute where the employer buys the members off because they have a bit of a nuisance claim. If the claim for arrears is compromised at, say, 25%, that's a tacit acceptance by both sides that probably the members aren't entitled to any arrears at all, or there's only a 25% chance that they might win. So would HMRC in those circumstances be able to say, well, actually, the true position is that the member isn't entitled to any arrears, therefore you can't justify this lump sum as a payment of pension, because there is and can be no entitlement to a pension at that level at all. I've seen one case where this has been dealt with in correspondence by the Revenue, where it appears that HMRC will accept that compromises, even at the sort of 25% level, or less than 50% level, can be treated as payments of pension. I think that's the right position. You can never, the problem with all of these areas, there being no definitive guidance, is that I can tell you what I've seen the Revenue say in one case, but you can never be sure they'll say the same thing in the next case. But my view is that there is a sound justification for accepting compromises even at a fairly low level, because the cause of action on the basis of which the claim is made is clearly retrospective to past years. And what the compromise is doing is essentially quantifying an otherwise unquantifiable claim to a pension. And it being an arm's length bargain, HMRC, on the basis of the authorities, really shouldn't be able to go behind that. And I don't think there can be any question that the compromise payment is actually a payment of pension, because that is the nature of the underlying cause of action. The paper that goes with this brief talk sets out some of the authorities and some of the reasoning there. But compromises should be all right. Now we'll just have a quick look at interest and then come on to look at some of the pitfalls in all that I've been saying. Interest is rather different to arrears because it's clearly not a payment of pension. Interest is a payment of money it's a payment to compensate you for being kept out of money. It's not a payment which can be slotted under section 1641A, nor are there any regulations which deal with it. The only pigeonhole you can slot interest payments into is as scheme administration payments, which are payments made for the purposes of the administration or management of the pension scheme. And it seems to me that interest payments, being inherent in the way that pension schemes are run, because underpayment of pensions are a frequent problem, even if only on a small scale, it seems to me that this is where interest payments must be fitted. They are simply made to compensate the member for late payment of his pension, and that's part of the administration or management of the scheme. HMRC guidance in the Pensions Tax Manual is very unhelpful. It doesn't mention interest as falling in this category at all. The main purpose of scheme administration payments is to justify payments of salaries to members of the scheme who work for the trustee, and to justify buying assets on an arm's length basis from members, which sometimes happens in small schemes. But the revenues say that it will also cover pensions ombudsman compensation by way of compensation for distress or inconvenience or other non-financial loss. So the absence of any mention of interest is a bit disturbing. Personally, I don't think it should be a problem, but it would be nice to have a definitive statement from HMRC to say that they also don't think it's a problem, but you will, as far as I can see, search in vain if you're looking for such a statement. Okay, so what are the pitfalls here? I've explained, certainly as far as arrears are concerned, that it ought to be able to you ought to be able to justify arrears as payments of pension and get them authorised in that way. Well, you do have to be careful around compromises because you will have to explain to HMRC, and they will expect an explanation as to how your arrears have arisen, and they will expect you to be able to allocate them from 1 year to the next. So you need to have a compromise basis which enables you to do that. You need to make sure that in the course of your compromise, you're not in the course of horse trading, allowing members to claim more arrears than they could possibly on any construction of the pension scheme be entitled to. You've got to be able to show that your compromise is as much as or less than a legal entitlement to pension that could have arisen. And also, there's a problem that it seems to me, although I don't take a different view, that you cannot create arrears for this purpose with retrospective effect. And you can see compromises where either through the exercise of a power of augmentation or a contractual agreement, members are given a retrospective increase in pension, which then generates a payment of arrears as at the date when the compromise is implemented. It seems to me to be absolutely critical, and again, I've seen revenue correspondence which I think indicates that they think this is the case as well. It seems to be absolutely critical that if you're to justify your arrears as payments of pension, you have to be able to show that they accrued at the time in the years past, and that at the end of any given tax year, the member could say, I had a right to those arrears in that year. What you can't do, consistent with the analysis which justifies treating arrears as payments of pension, is create them by means of the compromise and then seek artificially, as it were, retrospectively, by use of powers or contract to allocate them to earlier years. So you need to watch out for that. And another potential problem is that where members have had pensions put into payment at a lower level than they should have been in the past, very often they will say, well, we were unable to claim our full pension commencement lump sum, which of course is linked to the amount of the pension that you think you're entitled to. If your pension was put into payment at a rate which was 20% lower than it should have been, then you could have claimed a pension commencement lump sum which was 20% higher. I can't see a way of making payments under a compromise which clearly enables those payments to be authorised where there's simply payments made in respect of underpayment of pension lump sums which fell due in the past. And that's because pension commencement lump sums have to be paid not later than 1 year after the right to the pension arose. I mean, there are arguments which you might be able to run to justify claiming such payments as authorised, but they're by no means clear, and I think it remains to be seen whether HMRC would accept them. Okay, that's a very slide, just very quickly, because I come to the end of my time, summarising the consequences of unauthorised payments. It has to be said that sometimes you have to pay them, and if it's only on an individual member basis, although they can be expensive, sometimes they have to be paid. It is possible to, as I say here, to seek HMRC guidance, indeed clearance on an extra statutory basis to particular means of distributing the scheme, although in my experience it's generally pretty unhelpful. The acme of unhelpfulness from HMRC clearance was a case I saw last year in which they wrote back in respect of a query about the correct construction of a particular provision, nothing to do with arrears, where the solicitors very carefully set out construction A, construction B, which is the correct way of doing it, and HMRC wrote back and said, you're not entitled to clearance because the law is clear. But they then refused to say what the answer was. It was so clear that they said it didn't need to be addressed. So they can be unhelpful, but there is guidance and clearance in principle available. And if in doubt, you can, of course, seek indemnities for tax exposure from the employer or make retentions from payments to members until the tax position is clear. But the bottom line is that there are some potential pitfalls here. There are some difficulties. There are certainly areas where HMRC's guidance is in the Pensions Tax Manual is non-existent, but where I think it ought to exist. There are also other issues which I haven't got time to come on to, but which I will touch on in the paper, such as whether or not a payment of arrears and an uplift in pension as a result of a discovery of underpayments is a pensions input, whether or not it affects protection, whether or not it's a benefit crystallisation event. All of these issues for particular members may be important. None of them are subject to, as far as I can see, to much helpful guidance. So it's an area where you do need to take care, and it's an area where there are perhaps more pitfalls than are often appreciated. So that's, I think, all I have to say. My time is up, and I will stop sharing my screen and allow Robert to carry on.
Jonathan and Michael have been talking about the tax consequences of payments out of pension schemes. I'm going to consider, if you like, the other end of the process, things going into pension schemes, and in particular, whether tax relief at source is available in respect of in specie contributions to pension schemes, for example, shares, commercial property. And that was the subject matter of the Sippchoice case, which was decided by the upper tribunal in March of this year. The starting point is section 1881 of the 2004 Act, which gives tax relief on pension contributions paid. The official view has consistently been that the use of the word paid implies that relief is available only on contributions made in cash. I say it's always been, that was the position which was taken in the explanatory notes for what became section 188 when the Act was a bill. I have to say that if the matter stopped there, it would, in my view, be very questionable whether the use of the word paid in and of itself implies that only cash is eligible for relief. One speaks perfectly naturally about payment in kind, and if one trawls through the cases as they were trawled through before the tribunals, you can find lots of cases about payments of something other than cash. Gold mesh is a conspicuous example. But the revenue have consistently qualified this principle by saying that in certain circumstances, it's possible for a member to agree to pay a monetary contribution and then give effect to that cash contribution by a transfer of an asset in specie. And I've quoted on the slide part of the relevant paragraph of the pensions tax manual. This is something which has been very commonly relied upon since the 2004 Act regime came into effect in 2006. In the case, often with shares, commercial property, sometimes intellectual property rights, and it is something which was very useful for individuals who didn't have free cash which they could contribute to a scheme. When one looks at the way the revenue frame it in the manual, in the part of which I've quoted, it's obviously somewhat artificial, and particularly artificial in the case of a SIP, where the member is the person who's in control of investment on behalf of the scheme. But if one looks outside the field of the 2004 Act, there is, as the first tier tribunal pointed out, ample judicial authority on what constitutes a contribution in the context of contributions to various legal entities, for example, a company. And it's settled law that there's no requirement there for the company, for example, to receive money which a member pays to subscribe for shares and then buy goods or services with the cash from the subscriber. The company can simply issue shares as fully paid and treat the contributor's obligation as set off against the obligation to pay the contributor for goods and services. It's been said in the House of Lords in a case which I won't name because I'm not sure how to pronounce its name, that the circuitous process of passing over the money and passing it back is not essential. And though this was a common practice, starting off in about 2016, the revenue began to refuse relief on in specie contributions to SIPs. And according to press reports, they refused relief for the SIPs provided by at least 26 SIP providers. And the revenue said it had become concerned that the proper processes as identified in the manual were not being followed, and that some more exotic assets, like intellectual property rights, were being overvalued, resulting in costs, as they put it, to the taxpayer. I think they mean to the revenue. So one of the schemes where relief was refused was the Sippchoice scheme in question here. The facts, I can't go into the facts in great detail, but essentially what happened is that the prospective member applied to become a member of the scheme, and he filled in a contribution form, And I've set out on this slide 3 parts of what was in fact a box on the form, a table on the form, where the member declared that he proposed to make a net contribution to the SIP, and that this notification constitutes an irrevocable and binding obligation to make this contribution. And he agreed, he specified the net contribution and then said, I understand that by signing this declaration, I'm creating a legally binding and irrevocable contribution to make the specified contribution, and it won't be possible to change my mind. Sippchoice, the SIP provider, acknowledged receipt and told the member that by signing the declaration, they thought he had created a legally binding and irrevocable obligation to make the contribution. As I've said, relief was refused by the Revenue, and the matter went to the first tribunal, where Judge Gething allowed the SIP administrators appeal, but then the Revenue in turn appealed to the upper tribunal, who allowed the appeal. And in a nutshell, what they decided was that, construed in context, the phrase contributions paid meant paid in money, and didn't cover settlement by a transfer of assets, even if the transfer was made in satisfaction of an earlier obligation to contribute money. So the effect of that is that the qualification in the manual, which I set out earlier, is wrong. It isn't possible for a member to agree to pay a monetary contribution, then give effect to it by way of a transfer of an asset or assets. The tribunal was clear that an agreement to accept something other than money as performance of an obligation to pay in money doesn't convert the transfer of the something else into a payment of money. And the Revenue made an attempt to say that the interpretation that this was inconsistent with the manual was wrong, but not surprisingly, you may think, the tribunal rejected that. And the reasoning underlying this decision is was based very much on some other provisions of the relevant part of the legislation, which it was said effectively made no sense if contributions paid included in specie payments. Specifically, they had in mind section 195, which is a section headed transfer of certain shares to be treated as payments of payment of contributions. And the section is concerned with what it calls eligible shares, which are shares acquired under SAYE option schemes and shares appropriated to individuals under share incentive plans. And the effect of the section is to provide that references to contributions paid include contributions made in the form of a transfer by the individual of eligible shares within a permitted period. And essentially what the tribunal held was that it made no sense to construe the earlier provision, section 188, as including in specie contributions of shares, if it effectively would deprive section 195 and the restrictions which it imposed, in particular the time limit, which was effectively 90 days, from having any effect. Incidentally, it went on to say that it's the construction adopted by the upper tribunal removed what the revenue had said was the valuation problem. There was no mechanism for valuing assets transferred in specie. One immediately asks the question, is that the end of the story? It seemed to me quite clear that the criteria for grant of permission to go to the Court of Appeal would have been satisfied. But I understand that there hasn't even been an application for permission to appeal to the Court of Appeal for the simple reason that the amount at stake simply didn't justify it. In the case of the Sippchoice case, it's perhaps a little disappointing given the prevalence of these sorts of schemes that there hasn't been some sort of joinder of interest from other affected parties, but it appears that they haven't. What are the practical consequences? First of all, there is a concern that the revenue might seek to reverse and recoup relief which had already been given. That would, I think, involve an action for, in effect, restitution of that of the tax which was repaid to the scheme. It's difficult to see how that would succeed on ordinary restitutionary principles, because in making the payment, the revenue must have been taking the risk that the interpretation that it placed on the law was incorrect. What about the member? Can he get back the asset which has been put into the scheme? Again, it seems to me that that is not an easy claim to make for this reason, that one would have to show, I think, that there was a mistake falling within the principles set out by the Supreme Court in Pitt and Holt, such that it was unjust, unfair, or unconscionable for the scheme to hold on to the asset. So you arrive at the position that the asset is in the scheme, and the consequence of that, I think, must be that income and gains which accrue in the scheme are free of tax, though referable to the in specie contribution. And the result is that one gets an asymmetry in the treatment of the scheme going in and coming out. Normally, the position is that when a contribution is put into a registered pension scheme, there is tax relief at the beginning, but it isn't relief for all time. It is in effect a deferment until a payment is made out of the scheme, and that is taxed. But here you will still have the tax on the payment coming out of the scheme, albeit you haven't had the relief on the way in. On its view of the case, the upper tribunal didn't have to consider whether there was a debt, because whether or not there was a pre-existing debt, its conclusion led to the result that there was no scope for relief from tax. But it went on to find that there was in fact no contractual obligation to pay a sum of money. It rejected the taxpayer's argument, the SIP provider's argument, that the application form and contribution were a single package. And it analysed the promise of the member as a promise to make an in specie contribution, not a monetary payment which was then satisfied by a separate transfer of assets. If the case had been decided on the basis that there was non-compliance with the requirements which the revenue set out in the manual, one could see ways in which the documentation that was used could have been improved. And it is frequently a problem that if you set up complex arrangements of this sort, the people who are operating them on the ground will not understand the subtleties and sophistication of all the steps. But on the view that the tribunal take, you don't ever get to that. The final point I wanted to make was this: is this a situation where there is some public law remedy for SIP users who have scrupulously followed the guidance in the manual, but now find, in light of the upper tribunal decision, that they don't get the tax relief which they expected. This wasn't a point which arose for any form of decision in the upper tribunal, because there wasn't an application for judicial review before the tribunal. But I venture to suggest that it's difficult to think that the stringent requirements for establishing a legitimate expectation, the loss of which amounts to an abuse of power which can be restrained by judicial review, would not have been satisfied. General statements in manuals about the revenue's view of legislation are just that. And to get a legitimate expectation of abuse of power argument on the ground, off the ground, you really have to find something like a specific statement signed in blood by the revenue, and we don't get close to that. So that is what I wanted to say about the Sippchoice case. And I think we're supposed to have a slide at this point which said thank you, but it's gone. And I was going to thank not only the audience for their attention, but also, though it's not perhaps for me to do so, to thank those who've been responsible for organising this year's UG lectures, Tom and James Walmsley, who have been the members of Chambers involved in the organisation, and Hayley Eustace and her team, who've been responsible for all the hard work, and have put up with the strain of dealing with barristers who don't really know how to use Zoom and sharing their screens. Thank you very much.
Robert, thank you. I will certainly be thanking people. I think, given the time, what I'd like to do is take one question for Jonathan Davey, and I'm going to click the answer live button and read it out. Those of you who've asked questions to Michael, you should find they've been answered while we've all been online. If you click the answered tab in the Q&A, then you should find Michael's answers there. So thank you, Michael, for that. So I'm going to click answer live and read out the question for Jonathan in relation to the Clark case. So here it is. It's from Rowan Howard, so thank you, Rowan. Benefit errors are common. How much comfort can be taken from the obiter comments at para 86 of Clark? Jonathan, any thoughts on that?
Thank you. Thank you for that question. I think a reasonable amount of comfort can be taken from paragraph 86. I read it out earlier. I've got it again, and I'll read it out just to remind people what it says. different considerations may arguably arise in cases where an unauthorised payment is inadvertently or carelessly made, and the member concerned takes prompt and effective steps to restore it to the fund before any assessment is made by the revenue. Now, as I said earlier, the facts of the case in Clark, I think, weighed heavily on the Court of Appeal's shoulders. And if you look at the case law, Hillsdown, Venables, there's also a case called Thorpe. In each case, you find the court striving for what it considers to be a just outcome. So yes, paragraph 86, I think, is there for a reason. And I think to an extent, it's a nod towards the approach that the court has taken in some other cases. I'd also add this. In Clark, the court took the view that the policy, the purpose behind the unauthorised member payments charge was at least in part deterrent in character. Now, a deterrent purpose perhaps latches onto a scheme like Mr. Clark's with relative ease, but it doesn't, or at least much less obviously in relation to a simple unintended mistaken benefit payment. So I think, in short, yes, do take a reasonable amount of comfort from paragraph 86, but it goes without saying that prevention is better than cure. And so if mistakes can be avoided in the first place, so much the better.
Thank you, Jonathan. Can I apologise to those who asked questions and we haven't had time to answer them today? But I think given the time, I would like to bring today to a close by thanking all of you. This is the fourth and the last series in the series. I'm pleased to say we're going to be sending out by email later this week recordings of the 4 talks and the slides. And then in the coming weeks, papers written by the speakers to accompany them. So look out for those. The other thing I wanted to announce is one of the Wilberforce Hot Topic webinars coming up on the recent rectification case of Univar. Judgment handed down by Mr. Justice Trower a couple of weeks ago, Michael Furness and Tim Matthewson acting for the successful claimant, and they're presenting that webinar. Date to be confirmed, so please keep an eye on emails for that. But most importantly, some thank yous to the 216 of you who've joined today. Thank you very much. To those who've joined for the series, we've missed being with you in person. We've missed being able to catch up with your news and have a drink, but the next best thing has been to join you virtually. Thank you very much for being with us. I will certainly miss Wilberforce's equivalent of the Joe Wicks training sessions, mixing boundless enthusiasm with athleticism and great hair, which brings me to today's speakers. Thank you very much, Jonathan and Robert and Michael, for those talks, for all the hard work that lies behind them. And the hard work that lies behind them, thank you also very much to Hayley and to Harry for arranging them and letting them proceed so smoothly. It's all appreciated. We look forward very much to seeing you all soon. But with that, thank you and goodbye.